Hello and welcome to the first in our series of webinars on getting to grips with data protection. My name is Esma Kilic.
And my name is Mike Hibberd. And this afternoon we hope to provide you with a broad outline of the key issues and concepts of data protection. The purpose of today is to look at the concepts we will be exploring throughout this webinar series, in which we hope to enlighten you and your businesses on the various obligations under the data protection law and help you get to grips with data protection. Data protection is clearly a hot topic at the moment and never far from the media spotlight, as seen from the recent NHS ransomware attacks. A copy of these slides will be available after the webinar, and a copy of our contact details in the final slide should you have any questions. So the outline of today: first we're going to look at what is the Data Protection Act. This is the act that governs the current data protection laws. We'll look at the key concepts of data protection and why your business should be concerned with it. We'll then look at the 8 data protection principles which underline all of the obligations under the act and the rights and obligations for individuals and organisations under the act. Finally, we'll have a brief look at the changes coming up in May 2018 through the EU reforms.
So let's start with the Data Protection Act. What is it? The Data Protection Act controls how and when personal data can be lawfully processed by organisations or government bodies. The Act includes strict guidelines and privacy policies on how to keep personal data safe. Databases are easily accessed, searched and edited, but who's allowed to access this information and how accurate is this information? Could it be easily copied and distributed? And do we have the individual's permission to hold their information? And what about keeping a record of any changes made to the information? Before we go any further, I'll hand over to Mike to go through some key definitions.
So data protection law concerns the processing of personal data, but even that has a number of definitions within it. Data protection law applies to data controllers in the UK where personal data is processed in the context of that establishment. So data is information which is either processed by automatic means or manually processed in a filing system which is logically arranged, known as a relevant filing system. It includes filing records and online records. Search tools are an obvious example of this. If you search on Outlook or on Google for Mike Hibberd, all of the information you find there will be personal information. Processing is also defined by the Act, and it's defined very widely. It includes obtaining, recording or holding information or data, or carrying out any set of operations on the information or data. In practice, this covers everything, certainly when it comes to online records. So when we look at what personal data is, this is data, which we've just defined, relating to living individuals who can be identified from that data or from that data and other information in the possession of or likely to come in possession of the data controller. It includes expressions of opinion and any indication of the intention of a data controller or other person in respect of that information. Now on this slide we set out a number of examples, so names, addresses, contact information. The courts have suggested that personal data should have an individual as its focus and be of biographical significance. This means that minutes of a meeting, which simply have the name Mike Hibberd in there because he attended, will probably not be personal data. However, an email about Esma Kilic and Esma Kilic being named in that email with the email talking about her will be personal information. The Act also defines sensitive personal data. This is data relating to race, political opinions, health, sexual life, religious and other similar benefits, trade union membership and criminal records. The reason we flag this now is that there are higher hurdles and obligations for sensitive personal data compared to personal data. The next bullet point defines one of the key elements of the Data Protection Act, and that's the data controller against the data processor. Under the current legal framework, data protection obligations fall only on a data controller. A data controller is someone who determines the purposes for which and the manner in which any personal data is to be processed. In contrast, a data processor processes that data only on behalf of a data controller, but they don't get to determine the purposes for which it's processed or the manner in which it is held. A common example for businesses is a third-party payroll provider, where the business or organisation may hold the personal data and they simply give it to a third party to process the payroll, but that's all they use it for. And a data subject is any individual about whom data is processed. As a final point here, data protection is governed by the ICO, that's the Information Commissioner Officer. While it's sometimes dealt with in the courts, the first point of call will be the ICO, who have a number of guides online which may assist you when looking at data protection.
So, why should your business be concerned with it? Well, there are two main reasons: legal sanctions and damaging adverse publicity. Currently, a business in breach of the Act risks legal fines of up to £500,000 or imprisonment of those individuals who are responsible within the business. And these sanctions are to be increased under new law, the General Data Protection Regulation, and we'll come on to this later on in the webinar. A recent example of a fine issued by the ICO is a fine of £150,000 given to Basildon Borough Council for publishing sensitive personal information about a family online. When the council published a written statement in support of a householder's planning application for proposed works, it did not redact sensitive personal data relating to a static traveller family who had been living on the site for many years. In particular, it referred to the family's disability requirements, including mental health issues, the names of all the family members and their ages and the location of their home. The breach occurred as a result of failings in data protection procedures and training. An inexperienced council officer hadn't noticed the personal information in the statement, and there was no procedure in place for a second person to check the information being published. Though the ICO doesn't usually give out fines close to its £500,000 maximum limit, just by way of example, it did issue TalkTalk last year with a record £400,000 fine for technical security failings that allowed a cyber attacker to access customer data with ease. This was a failing that could have been prevented if TalkTalk had taken basic steps to protect customers' information. Any false step in the area of data protection also attracts intense media scrutiny. Think of the NHS ransomware attacks that happened last month. It is known as the WannaCry ransomware attacks, and it affected companies across the globe. The attack exploited a flaw in older unsupported versions of the Microsoft Windows operating systems. Now, in the case of the NHS, it received some criticism over why it had not yet updated its systems and kept its records safe. Whilst the NHS argued there was no evidence that patients' medical records had been accessed, it could not confirm whether the hackers had the ability to destroy the records if the ransom was not paid. A security breach of this nature can mean life or death for individuals concerned. Now, with potentially significant damage to your business's reputation, businesses simply cannot afford to ignore their data protection obligations. The level of fines and what they relate to shows the importance of protecting data. Look out for news in the media and ensure you are on top of the latest warnings and prepare your business. Data protection is about ensuring you have an effective system in place to manage and protect data. This includes up-to-date IT systems and comprehensive training programs for your employees so that they not only know what to do with the information and appreciate its confidentiality, but ensure they act within authority when handling personal data.
So turning to the 8 data protection principles, if your organisation complies with these, then they're very likely to be complying with their data protection obligations and at least showing that they've taken the concerns seriously. So to comply with the principles, data must firstly be fairly and lawfully processed, obtained for specified lawful purposes, adequate, relevant and not excessive for the purposes for which it is processed, accurate and where necessary kept up to date, kept for no longer than is necessary, processed in accordance with the rights of data subjects under the DPA, safeguarded by appropriate technical and organisational security measures. We've already touched on the WannaCry ransomware attack and the potential consequences if this isn't met. And it should not be transferred outside the EEA, the European Economic Area, unless the destination country ensures an adequate level of protection for data subjects. So turning to the first principle, which is one of the key principles under the Act, fair and lawful processing. The Act itself sets out a number of conditions that may be met for lawful processing. The most common criteria used is consent. So a data controller will often seek a data subject's consent to process their data. For example, in employment contracts, there may be a separate clause setting out the circumstances in which personal data will be processed, and an employee has to signify their consent to this. Any consent that's relied on needs to set out a number of scenarios in which your organisation thinks the data will be processed, so that you can get a data subject consent at that time. What you cannot do is get a weak consent and then process data outside the principles you already set out in the consent form, because the individual's not consented to this. There are other criteria under the Data Protection Act for data to be processed. For example, data can be processed where it's necessary to perform a contract with the individual, or for taking steps to comply with requests made by an individual with a view to entering into a contract. It's necessary to comply with a legal obligation of the data controller, necessary for the administration of justice, or for the legitimate interests of the data controller or a third party to whom the data is disclosed. As mentioned earlier, there's a distinction in the Act between personal data and sensitive personal data. The reason for the distinction is there are further conditions for sensitive personal data to be fairly and lawfully processed. For example, with consent, you have to get explicit consent. This essentially means that a data subject has to very clearly indicate his agreement to the data being processed in a certain way. So when looking at consent, it's always advisable to get opt-in consent if you can, where an individual or data subject signs their agreement to their data being processed in a certain way and has to make a positive indication, rather than one where they simply are assumed to have consented. Another example is the legitimate interests basis on which personal data can be processed can only be vital interests if it's in relation to sensitive personal data. Now, the ICO in their guidance suggests this is unlikely to be satisfied other than in a life or death situation. The second and third principles are fairly self-explanatory. Data must only be obtained for specified lawful purposes, and it must be adequate, relevant, and not excessive for the purposes for which it is processed. This means a data controller needs to review the data that they hold and make sure that, as well as being relevant, it's still needed.
The fourth principle is that information must be accurate and kept up to date. As a business, it is your duty to ensure the personal data you obtain is accurate. And how do you do that? You will have to look at the nature of the personal data and what it will be used for. The more important it is for your business that the personal data is accurate, the greater effort you will need to make. So if you'll be using the data to make a decision that may significantly affect the individual concerned or others, you'll clearly need to take more steps to make sure the data is accurate. For example, an employer might need to check the precise details of a job applicant's qualifications or work experience with a previous employer if it is essential for that particular role. Always ensure that the source of any personal data is clear. Carefully consider any challenges to the accuracy of the information. Consider whether it is necessary to update the information. Do you need the individual to reconfirm or check that the information remains correct, and if necessary, make any amendments? The fifth principle is that information should not be kept for longer than necessary. Assuming that you have a valid reason for processing the personal data to begin with, discarding data too soon would be likely to disadvantage your business and be an inconvenience to those individuals the information relates to. Going to the other end of the spectrum, keeping personal data for too long might lead to the following issues: an increased risk of outdated personal data and that data being used to the detriment of the individual concerned. Although you may no longer need the personal data, you must still use your resources to make sure it is held securely. Responding to subject access requests for any personal data might be difficult if you are holding more data than you need. I'll come on to subject access requests in the next principle. So personal data held for longer than necessary will, by definition, be excessive and may also be irrelevant. In any event, it is inefficient and can be costly to hold more information than necessary. Coming on to the sixth, the rights of the individual, referred to in the sixth principle of processing in line with data subjects' rights, is the subject access request. When an individual makes a written request and pays a fee amongst a few other rights, it is entitled to be told whether any personal data is being processed, given a description of the personal data, the reasons it is being processed, and whether it will be given to any other organizations or people. It is also entitled to be given a copy of the information comprising the data and a right to object to processing that is likely to cause or is causing damage or distress. A right in certain circumstances to have inaccurate personal data rectified, blocked, erased or destroyed, and a right to claim compensation for damages caused by a breach of the Act. We'll take a look at subject access requests and how to comply with such requests later on in the series of webinars. Moving on to perhaps one of the more exciting principles, security, the protection of the personal data. Security is the seventh data protection principle. Securing personal data means taking appropriate technical and organizational measures against unauthorized or unlawful processing of personal data and taking measures against accidental loss, damage, or destruction of personal data. In practice, this means you must have appropriate security measures to prevent the personal data you hold being accidentally or deliberately compromised. In particular, you'll need to design and organize your security to fit the nature of the personal data you hold and the harm that may result from a security breach. Be clear about who in your organization is responsible for ensuring information security. Make sure you have the right physical and technical security backed up by robust policies and procedures and reliable, well-trained staff, and be ready to respond to any breach of security swiftly and effectively. If your business does not have appropriate security measures in place, you'll be at risk of reputational damage and receiving fines like those organizations I mentioned at the start. A security breach resulting in loss of personal data may cause real harm and distress to the individuals concerned and might even put their lives at risk. Think of the NHS ransomware attacks. As a result of these, many patients' operations were cancelled. Other examples of harm or loss can include fake credit card transactions, witnesses or offenders at risk of physical harm or intimidation, exposure of the addresses of service personnel, police and prison officers, and women at risk of domestic violence. It is important to understand that the legal requirements relate to the security of every aspect of your processing of personal data and not just the way in which it is stored in your systems. The law requires you to think about the nature of the information you collect and the harm that might result from its improper use or from its accidental loss or destruction. These will help you determine the measures you need to have in place. And finally, to quickly touch upon the eighth principle, adequate protection before transferring internationally. This rule states that personal data shall not be transferred to a country outside the European Economic Area unless there is an adequate level of protection for rights and freedoms of data subjects in relation to the processing of personal data. A couple of things to think about here. Is the transfer to a country on the EU Commission's list of countries providing adequate protection of personal data and individuals' rights? Transfers may be made to any country or territory in respect of which the Commission has made a positive finding of Adequacy. If the transfer is to the US, has the US recipient of the data provided adequate protection for the transfer of personal data? A good place to start is to see if the organisation you're planning to transfer data to in the US is or is looking to become a part of the Privacy Shield scheme. This is a scheme providing companies on both sides of the Atlantic with a mechanism to comply with data protection requirements when transferring personal data to the US.
Turning now to the rights and obligations of data controllers and data subjects under the Act. The first thing to note is that data controllers must notify the ICO before processing data. If you take one take-home message from this webinar today, if your organisation is not registered with the ICO, you need to do this right now as a matter of urgency. Registration is done online on the link on the slides, which will be provided to you after the webinar, and there's a set of prescribed information that you must give to the ICO. This includes the name and address of the data controller, a description of the personal data being or to be processed by the data controller, a description of the category or categories of data subject to which they relate, and a description of the purpose or purposes for which the data is being or is to be processed, and a description of any recipient or class of recipients. You may remember from my earlier slides that data has to be processed fairly and lawfully, and so this is you registering to the ICO that you are going to be dealing with this. A failure to register is a criminal offence. Registration is done by that link and there is a fee. For most organisations this will be £35. However, for organisations with an annual turnover of 25.9 million or more and employing 250 or more members of staff, there is a £500 fee. The third bullet point here relates to one of the key weapons of data protection, and this is rights of access for individuals. This will be considered in detail in a later webinar, but essentially an individual has the right to know what data a data controller has on them, and is allowed to see a copy of that as well. So it's a key weapon for individuals. In relation to your registration with the ICO, this has to be updated annually and you have to pay a fee each year that you give the further information.
And finally, the third-party processing. It is the control rather than possession of personal data that is the determining factor here. So, where data is processed on behalf of your business, being the data controller, by another party being the data processor, the controller is required to ensure that the processor has implemented the necessary security measures in relation to such data. The controller must also enter into a written contract with the processor which requires the processor to act only on instructions from the controller and to ensure adequate security measures are in place. This might be relevant, for example, where the data controller by you as your business is processing, having a third party process their information as part of an arrangement where you outsource some of your IT functions or engage a cloud service provider.
Just to briefly touch on the upcoming changes, the EU are bringing in some data protection reforms next year which are going to impact all businesses. They will be effective from the 25th of May next year and are being hailed as the biggest shake-up for consumers' data protection rights for 3 decades. Now, despite any terms of Brexit and despite the UK leaving the European Union, these regulations are going to be put into force, and the government confirmed this in November of last year. Now, there are a number of changes coming under the regulations, but the ICO have already said that it's a strong starting point for the upcoming changes to be complying with the obligations under the Act. Essentially, get your data protection obligations in line now and it will make any changes coming up a lot simpler. We will be dealing with the detailed changes coming about in the next webinar in this series. But the key changes for you to note as the headlines: liability will rest both with data controllers and data processors, unlike the current UK law where it's only data controllers. there will be a significant increase in fines that the regulating body, so the ICO, can dish out. There will be up to 20 million or 4% of annual worldwide turnover for any key breaches. Whether the ICO will go to that higher level of fine will remain to be seen, and consent will be harder to rely on. So essentially, all the data protection principles we've outlined today need to be considered by your organisation now, so that when the changes come in, your business is adequately prepared. And finally, I've just put some links onto the final slide here. So the ICO give a lot of guidance to organisations if you don't understand any of the data protection obligations or want to see what the ICO will say, because they have the final say on data protection. You'll be sent a copy of the slides after the webinar, so I hope these will be useful to you. So the next webinar will be on the 24th of July, which will look in detail on the EU regulations that I was just discussing. Any questions you have on the outline we've provided today can be forwarded to myself or Esma at the contact details below.
I just want to say thank you very much for listening to our webinar and hope the information was useful.
Thank you.